Welcome back. We will start with section 99A. No order under section 47 to be reversed or modified unless decision of the case is prejudicially affected. Without prejudice to the generality of the provisions of section 99, no order under section 47 shall be reversed or substantially varied on account of any error, defect, or irregularity has prejudicially affected the decision of the case. So, wherever section 47 is looked at, section 99A says wherever there is a decree which has been passed under section 47, it need not be reversed or modified if it does not prejudicially affect the case. Prejudicially affect the case means what? The case, there is no due justice which has been given to the parties. Okay. So, if it does not prejudice the parties or the case, merits of the case in any matter, then in that case, the decree need not be reversed or modified. Okay. Next, we go to the next subheading, appeals from appellate courts. Till now, what we saw was from the original decrees, right? Now, we go to appellate decrees. Second appeal, section 100, second appeal. Save as otherwise provided in the expressly provided in the body of this code. See, whenever, like what mistake I did now, you should not do that mistake. Why? Because expressly provided. Expressly means what? It is written or it is very clear from the code that is the procedure, right? So, expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court if the High Court is satisfied that the case involves substantial question of law. See, question of fact, it can be filed before the other appellate courts, right? Say for example, if it is in taluk level, then it will go to the other next level. Then it will go to the district court. Am I right? From district court, it will go to the High Court. But in certain cases, the second appeal will lie directly to the High Court where there is a question of law. It's not a question of fact, it's a question of law. An appeal may lie under this section from an appellate decree passed ex parte. Same thing what we read in the original decree. If a decree has been passed ex parte, even then the appeal shall lie. When the High Court is satisfied that a substantial question of law is involved in any case, it shall formulate that question. So, wherever there is a question of law which has to be decided upon, the High Court will formulate the question of law. The appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question. Obviously, whenever an appeal is filed, the other party, okay, he shall be allowed to argue that there is no question of law which arises. It's common. Provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question. See, sometimes what happens when we are filing an appeal, we ourselves will state a question of law over there. Sometimes, not always. Okay, we will state a question of law and then the High Court will respond to it, right? So, it can either be the High Court which is formulating the question, or the question can be formulated by the court. How will we do it? The question can be formulated by the court, other court, but High Court, even though it is not formulating the question, has the power to decide upon the question of law. Okay. Then next we go to section 100A. No further appeal in certain cases. This is very important to remember. I mean, because those who are practicing, it is quite easy for them because they will remember as it is. But some of us who are not practicing, some others who are not practicing, for them this section they have to remember. Okay. No further appeal in certain cases. Notwithstanding anything contained in any letters patent for any High Court or in any instrument having the force of law, or in any other law for the timing in force, where any appeal from an original or appellate decree or order is heard and decided by a single judge of a high court, no further appeal shall lie. So, where the appeal has been filed before a single judge of the high court, there is only one judge in the bench, right? A single judge, single judgment. Okay. So, where the appeal has been heard by a single bench, single judgment, then no appeal shall lie from such decree. Such orders, okay, of the High Court. Then section 101, second appeal on no other grounds. No second appeal shall be except on the grounds mentioned in section 100. We have already seen what are all the grounds on which second appeal can be filed. Am I right? So that one. Then next we go to section 102. No second appeal in certain cases. No second appeal shall lie from any decree where the subject matter of the original suit is for recovery of money not exceeding 25,000 rupees. So if it exceeds 25,000 rupees, then there can be an appeal. But if it does not exceed, recovery of money cases, okay, if it does not exceed 25,000 rupees, then there cannot be any second appeal. Next we go to section Next we go to section 103, power of High Court to determine issue of fact. We have already seen High Court appeal can be filed on the question of law, right? Okay, now we go to whether it can do it on the case or issue of fact. In any second appeal, the High Court may, if the evidence on the record is sufficient, determine any issue necessary for disposal of the appeal. How will it go to the High Court on the second one? First we file it in the court of first instance, then we go to the higher authority, and then it goes to the High Court, right? Okay. Power of High Court to determine issue of fact. It can determine the issue of fact provided. What are all the circumstances? A, which has not been determined by the lower appellate court or both by the court of first instance and lower appellate court, where there is an issue of fact, okay, but it has not been considered. That means what? Either the court has read about it but is not examined it. Clear? So which are the courts which have not examined it? The court of original instance and the court of lower appellate court. Okay. You can underline the word and over there. It is not or. It is and. See, when we are reading law, you try to interpret it. Okay. Because in law usually there is a lot of difference between and or. Clear? So you should always keep in mind. It is not just IPC, where they say punishment or fine or both. It's not just IPC which is important. For all these interpretations. What I mean to say, even while reading any other book for that matter, okay, any act for that matter, please see whether it is and or, okay, or whether it is both. Some places have it, right? So here it is, it has not been determined by the court of first instance and the lower appellate court. So both the courts have not considered the question of fact. Clear? B, which has been wrongly determined by such court, underline, wrongly determined by such court or courts by reason of a decision on such question of law as is referred to in section 100. See, when we are talking about it has been wrongly determined by such court, it has been considered. First instance we saw where it is not considered at all. Second one is what? It has considered. It has been considered by the original court and the lower appellate court. But what has happened? The question of law which it faced was not considerably considered. Clear? So which has been wrongly determined by such court or courts by reason of a decision on such question of law as is referred to in section 100. Where there has been an interpretation of a question of law, it has been wrongly interpreted and the decree has been given. Clear? Then we go to the next subheading, appeals from orders. Section 104, orders from which appeal lies. Here it is very detailed, so you will get to know easily what are the orders. An appeal shall lie from the following orders and save as otherwise expressly provided in the body of this code or by any law for the timing in force from no other orders. So which are the orders from which appeal lies? Number 1, an order made under section 35A. You can, when we are reading this, you can just go through the previous sections we have covered and look into it. Okay, what is section 47, what is section 35A? Please go through all those things and make a note of it by the side, so that when you are reading it for the second time, you will know it. Okay, an order and section 35A. Next one, an order under section 91 or 92 refusing leave to institute a suit of the nature referred to in section 91 or 92 as the case may be. So one thing is where it is section 35A. Second one, a person wanted to file, the plaintiff wanted to file a suit under section 91 or 92 but was not allowed to do so. So that person can file an appeal. Number 3, an order under section 95. Then an order under any of the provisions of this code imposing a fine or directing the arrest or detention in civil prison of any person except where such arrest or detention is in execution of a decree. Where else did we see about arrest and detention? We saw it in attachment, right? Okay. Any order made under the rules from which an appeal is expressly allowed. We have already seen that. The next one, provided that no appeal shall lie against any order specified in clause FF. That's the first one which we did. Save on the ground that no order or an order for the payment of a less amount ought to have been made. No appeal shall lie from any order passed in appeal under this section. Where an appeal has already been filed, and the case has been decreed, once again the appeal cannot be filed. Okay. Then section 105, other orders, save as otherwise expressly provided, no appeal shall lie from any order made by the civil court in the exercise of its jurisdiction or appellate jurisdiction, but, underline the word but, where a decree is appealed from any error, defect, irregularity in any order affecting the decision of the case. We have already seen, no? Where it does not affect the, where it does not affect the merits or the jurisdiction, no appeal can be filed. But here we are seeing that it is affecting the decision of the case, may set forth as a ground of objection in the memorandum of appeal. Okay, so where the aggrieved party, the party has been aggrieved by a decree, in that case, the appeal can be filed. Notwithstanding anything contained in subsection 1, where any party aggrieved by an order of remand from which an appeal lies does not appeal therefrom, he shall thereafter be precluded from disputing its correctness. See, where there has been a party has been aggrieved because there has been an order for remand. Remand means what? Sending back the case. Am I right? So a person, the party has been aggrieved. That means what? He is suffering due to the remand. But at the time of remand, he doesn't give any objection. Later, he cannot say, no, the remand should not have been done. Clear? The next one, section 106. What courts to hear appeal? Where an appeal from any order is allowed, it shall lie to the court to which an appeal would lie from the decree in the suit. That means what? Whichever is the jurisdictional court according to the code, appeal lies to that particular court. Or where such order is made by a court not being a high court in the exercise of appellate jurisdiction, then to the high court. It shall all appeals shall go to high court, but if it is not an order made by the High Court, but if it is an order made by some other court, then the appeal shall lie to the High Court. Okay, first appeal, second appeal, whichever is the appeal. The next subsection, the next subheading, general provisions relating to appeals. So, what are the general provisions which relate to appeals? Section 107, powers of the appellate court. Subject to such conditions and limitations as may be prescribed, an appellate court shall have power to determine a case finally, number 1. Number 2, to remand a case. Number 3, to frame issues and refer them for trial. Sometimes what happens, the very basic of the case would not have been considered properly. So in that case, some or probably some additional allegations have been made. So in such cases, the appellate court can frame issues and remand the case back for trial. In that itself, subsection 2, subject as aforesaid, the appellate court shall have the same powers and perform as nearly the same duties as are conferred and imposed by this code on courts of original jurisdiction in respect of suits instituted therein. So wherever the courts are hearing appeal cases, appellate courts, okay, they have the same rights and powers as that of the court of original jurisdiction. That means what? They have the right to issue notices, they have the right to issue summons, they have the right to order for appearance of any of the parties, they have the right to hear evidences, take up applications, decide upon applications, everything is there. Okay. Then next one, 108. Procedure in appeals from appellate decrees and orders. The provisions of this part relating to appeals from original decree shall, so far as may be, applied to appeals from appellate decree and orders made under this code or under any special or local law in which a different procedure is not provided. Okay, so wherever there is a decree, original decree, and it needs to go on appeal, it can go on appeal, either from original decree or from appellate court. Okay, provided there is no other special provisions which is affecting. See, for example, when we are looking at Consumer Protection Act, right? That's also a civil case. Okay, Family Courts Act, that's also a civil case. But what happens? We cannot go on appeal because it has a different provisions. I mean, there is a different set of court which is there. So again, they cannot come in appeal to the district court or anything like that because they themselves are district courts in their own right. So the appeal can go only to the High Court, not other district courts. Clear? Then, next one, appeals to the Supreme Court. That's the subheading. Section 109. When appeals lie to the Supreme Court. Very important. I'm not telling you very important on the basis of the exam type or viva type or anything. You just need to know the procedure. Even if it is for practicing law, you should know the procedure to a certain extent. Practically, when we go to the court, it differs, okay? But we should know the procedure at least to a certain extent so that we can manage. Okay? Section 109. When appeals lie to the Supreme Court. Subject to the provisions in Chapter 4 of Part 5 of the Constitution and such rules as may from time to time be made by the Supreme Court regarding appeals from the courts of India and to the provisions herein contained, an appeal shall lie to the Supreme Court when from any judgment, decree or final order in a civil proceeding of a High Court, if the High Court certifies. That's very, very important. That's why I told you. Underline there. It is not like other cases, where, the district court is telling like this, let me go to the High Court. It's not like that. Okay. Going on appeal to Supreme Court involves a different procedure. Okay. So you can underline there. If the High Court, underline that. If the High Court certifies that the case involves a substantial question of law of general importance. General importance is very important. Why? Because if I am filing a case, okay, and I am aggrieved by certain order, I am going to the High Court, and then I want to go to the Supreme Court. Clear? So when I am going to the Supreme Court, then the High Court should give me a certificate saying that this is of general importance and it involves a question of law. Number one. Okay. Number two, that in the opinion of the High Court, the said question needs to be decided by the Supreme Court. Whatever is a question of law, it should be decided by the Supreme Court. Clear? Then section 110, value of subject matter, it has been omitted. 111 has also been omitted. 111A section has also been omitted. Then we go to section 112, that's the savings clause. Nothing contained in this court shall be deemed to affect the powers of the Supreme Court under Article 136 or any other provisions of the Constitution. Just because certain powers of the Supreme Court are mentioned in the CPC, it doesn't mean that the Supreme Court has only these powers and not those powers which are mentioned in the Constitution. B. To interfere with any rules made by the Supreme Court and for the time being in force for the presentation of appeals to that court or their conduct before that court. See, where the appeal lies before the Supreme Court, okay? We can file before the Supreme Court and the case can be conducted. If we don't want also, we can just conduct the case and leave it. Nothing herein contained applies to any matter of criminal or admiralty or vice admiralty jurisdiction or to appeals from orders and decrees or prize courts. Okay? So, nothing. It doesn't apply to criminal cases. It doesn't apply to admiralty or vice admiralty. Means what? Army. And not necessarily army, defense. Right? Jurisdiction or to appeals from orders and decrees of prize courts. Prize courts are what? They are all from the UK. Part 8, Part 8, reference, review and revision. Part 8. Section 113, reference to High Court. Subject to such conditions and limitations as may be prescribed, any court may state a case and refer the same for opinion of the High Court, and the High Court may make such order thereon as it thinks fit. So what? There is a statement of opinion. It's not necessarily a dispute, okay? So where there is a statement of opinion on a question of law, okay? So where there is a statement of opinion, or say there is a situation which is given and the government or anyone wants to know the opinion of the court, then that shall be stated and it shall be sent to the High Court for its opinion. Provided that where the court is satisfied that the case pending before it involves a question as to the validity of any act, ordinance or regulation or any provision contained in an act, ordinance or regulation, the determination of which is necessary for the disposal of the case and is of the opinion that such act, ordinance, regulation or provision is invalid or inoperative but has not been so declared by the High Court to which the court is subordinate or by reasons therefore, and refer the same for opinion of the court. Okay. So what does this mean? The court is satisfied that the case pending before it involves a question as to the validity of any act, ordinance or regulation. Okay, this is the main thing. Or, that's the first one. Number 2, or of any provision contained in an act, ordinance or regulation, the determination of which is necessary. Understand? Determination, underline, necessary, underline, for the disposal of the case, and is of the opinion that such act, ordinance, regulation or provision is invalid or inoperative but has not been so declared by the High Court to which that court is subordinate. Okay. So number 1, what? there should be a case pending before it as to the question whether any act, ordinance, or regulation is valid. Okay. Number 2, where the act, ordinance, or regulation is invalid, in that case, but has not been so declared by the High Court. It has not been declared by the High Court to have been, what do you say, well, violation of the act, that is validity. Okay. Invalidity of an act, ordinance, or regulation. Clear? So what is the explanation to this? In this section, regulation means any regulation of Bengal, Bombay, or Madras Code, or regulation as defined in the Central Clauses Act 1897. General Clauses Act, not Central. General Clauses Act 1897. Clear? So this is as far as we have just started with the reference. We will go on with this in the next class. Okay. Thank you.